Dr. Ahmed and MonaLaw, I wish to welcome all of you, colleagues, friends, alumni, students, to yet another in the MonaLaw Masterclass series, or public-facing graduate classrooms. Today's masterclass is in the Advanced International Human Rights LLM class of Dr. Ramona Biholar, and it focuses on the neglected century-old UNIA Declaration of Rights of Negro Peoples of the World, which was adopted at the UNIA's 1920 Harlem Convention, presided over by Marcus Garvey at Liberty Hall. This masterclass, with its 3 guest teachers and the course director, is not simply a response to UWI's goal to be a university for all, global, but rooted in the Caribbean. It is also born of the university's determination to be aligned to our world's needs. And without question, that includes the need to address enduring systemic racial inequality. The UNIA Declaration began, be it resolved, that the Negro peoples of the world, in the year of our Lord, 1920, protest against the wrongs and injustices they are suffering, and state what they deem their fair and just rights, as well as the treatment they propose to demand of all men in the future. Unquote. Regrettably, a century later, these words still ring true. In the centenary of that declaration in the summer of 2020, the African descendants of the world repeated that call all around the world, the precise call about the disregard for Black lives. And they echoed, as they did in 1920, the call for justice. This afternoon, Dr. Stephen Jensen, senior researcher at the Danish Institute for Human Rights, a historian of human rights, will offer the main presentation, which looks at the history of this declaration. His acclaimed book, The Making of International Human Rights, tells a story of how countries like Jamaica contributed to constructing the international human rights system that we have today. We'll have shorter comments from Dr. Ahmed Reid, another historian at CUNY. He's a member of the UN Working Group of Experts on People of African Descent, established by the Human Rights Council. He will discuss reparation, justice, and development, Marcus Garvey, and the UN decade, the United Nations International Decade for People of African Descent. Following him will be brief comments from the Jamaican human rights lawyer, Kacy Mordecai. She's a staff attorney, senior staff attorney at the Robert F. Kennedy Human Rights based in Washington, D.C., and she has been working for years on behalf of Haitians and persons of Haitian descent who have often, despite their membership in the Caribbean community, been deprived of the right to have rights in our own region. And the title of her presentation is The Color of Nationality, Anti-Haitianism in the Caribbean. And then finally, we'll have the course director, Ramona Biholar, offering her comments, reading the declaration in light of the recent Virgo case, dealing with a Black child with locks who wasn't Rastafari, but as one would expect, wanted to keep her hair in locks for primary school and encountered a challenge. Ramona has not only been teaching international human rights law in the Faculty of Law, both at the graduate and undergraduate level for years, she's also been training state officials and civil society leaders across the region on reporting human rights through human rights treaty bodies and the Human Rights Council in the Universal Periodic Review processes. Before turning over to Stephen, I want to recognize all the graduate and undergraduate students who are both in the classroom and watching on YouTube, as well as all of you who have joined us. Let me also recognize some special guests in the classroom. Senator the Honorable Tom Tavares Finson, President of the Senate, the Commissioner, former President of the Inter-American Commission on Human Rights, Margaret May Macaulay, who is the Rapporteur on the rights of persons of African descent and against racism in the Inter-American system. Stephen Golding, the President of the UNIA in Jamaica, and a number of human rights activists and longtime defenders of human rights are also here. Welcome to all of you. Thank you for joining us today. And let me hand over to Ramona for a second to tell you about sending questions to us during the session before moving to Stephen. Ramona?
Thank you, Tracy. And I wanted to join you by welcoming everybody, fellow panelists and especially invited guests, LLM students, colleagues on both Zoom and on YouTube to this masterclass in the LLM course, Advanced International Human Rights Law. Very happy to have you join us for what promises to be an insightful discussion about an important but neglected human rights document, the UNIA Declaration. So just briefly, some housekeeping points. If you have comments or questions, please place them in the Zoom or YouTube chat. So my co-moderator and and I will monitor them, and at the time of the Q&A, we'll pose them to the panelists. Tracy, over to you.
Thank you, Ramona. I'll hand over straight to Stephen Jensen to tell us about the history of this important declaration. Stephen, the floor is yours.
Good evening, everyone from Copenhagen, and greetings. And thank you very much to Tracy, Ramona, Andrew, and Ishmael for organizing this and making it happen. It's a pleasure to have the opportunity to speak to you, and I'm grateful that the law school has a continued interest in my research, and I'm happy I have the chance to present to you even with the restrictions of our current times. So I will be speaking and give some historical perspective on the 1920 Declaration, and I have split my presentation in 4 themes. First, I'll try and explore why we should study the 1920 Declaration. Then I'll provide some historical context to in which the 1920 Declaration was drafted. And then I'll look a little bit at the drafting process and the content of the declaration. And then as the 4th and final point, look at some of the legacies from this declaration, and also, I think, issues that should be explored further. So about a decade ago, I started out with the intention to write a history of the evolution of human rights since 1945. And I quickly realized that there were some major gaps in this history. It was very much structured around Western actors and Western time. And I didn't know at that point that I would also be spending the last 10 years on Jamaica-related issues, because Jamaica and the Caribbean is so central to this international history of human rights that it's a major omission that it has not been clear how it fits in. The first step that my research took me was to the 1960s, realizing that Jamaica was really the leader in the global human rights field, the leader in international human rights diplomacy, very much coming just after independence and leading the human rights work at the UN within 2 years of independence. And that work focused very much on the Ambassador Egerton Richardson, and that's a major theme in my book. As I explored this further, I also wanted to look at some of the domestic kind of drivers of this. And I was surprised when a few years ago in the National Archives out in Spanish time discovered that there was actually a government human rights policy declared in January 1961. And that reflected not just the Jamaica-wide, but a kind of West Indies-wide debate, public debate around the social and economic developments that the region was taking. And this was a government policy announced by the Norman Manley government. So that was the space I was operating in. But then I encountered the 1920 Declaration during an event at the UWI Law faculty, namely the 70th anniversary of the Universal Declaration of Human Rights in December 2018. And this was Tracy Robinson and Rupert Lewis that brought the 1920 Declaration into this context and into that anniversary celebration, making sure that the 1920 Declaration was not forgotten. And when I first read the Declaration, I was astounded by its rich content, and I was also intrigued. Why someone who has spent almost a decade at that point trying to write international human rights history in the 20th century was I not aware, had I not heard of this declaration? And why was it not integrated into the 20th century history of international human rights? So I asked Professor Lewis for reading materials, because surely I could learn more by reading some of the Garvey scholarship. And Professor Lewis said he knew of none. So, and that turned out to be completely right. But he pointed me towards the multi-volume Marcus Garvey papers, so I could go to the sources and try and track this story. Because this story had to be written without a doubt. And I worked my way through a large part of the Garvey scholarship when I was a visiting researcher at the University of Oxford in late 2019, literally going through book by book, shelf by shelf of Garvey scholarship to find out, was there anything out there about this 1920 Declaration? And this work actually affirmed that the 1920 Declaration of Rights of the Negro peoples of the world had never been subject to the attention it rightfully deserves. It's not that the declaration was completely unknown. It was mainly just mentioned in passing. And sometimes this was done merely through a one-line statement acknowledging its existence, but not exploring it further. Not the content or not the kind of the purpose and the rationale for writing this remarkable declaration. But at times the one-line statement actually pointed towards so much more, but without following up on it. So in 2006, the historian Robert Trent Winson wrote, and I'm quoting, "The Declaration of Rights of the Negro Peoples of the World articulated the grievances, aims, objectives, and guiding philosophy of the Universal Negro Improvement Association as an anti-white supremacist movement." And one scholar observed in 1991 about the declaration, "The fact that these issues are still relevant is testimony to the substantive basis of the issues discussed during the first UNI convention in 1920, end quote. And in referring to the 1920 declaration, Rupert Lewis once wrote, and I'm quoting, "Garveyism should be assessed in relation to its adherence to this democratically determined document." And so my own position very soon became clear. Not only was the 1920 declaration an impressive political and intellectual document and achievement, I think it should be regarded as one of the main civil society human rights documents from the 20th century, equal in stature to documents such as the 1955 ANC Freedom Charter from South Africa and the Charter 77 document prepared by Václav Havel and other Czechoslovak dissidents at a key moment in the Cold War. So this is the historical stature I would place this document within. So if we look at the historical context in which it was drafted, it really is a document that speaks to human rights issues across the 20th century and into the 21st century. But its place in time is very clear, also from the debates and the speeches at the convention in Harlem in August 1920. There's a very clear link to a post-First World War context of Black soldiers returning from war in Europe. This is a time where there was a sharp increase in lynching in the US, especially 1918 was a disastrous year in terms of the increase, devastating year. It was also a period where empires were falling in Europe, and self-determination was on the agenda, pushed by US President Woodrow Wilson in the context of the debates about the creation of the League of Nations. All of these events and kind of on a global scale are part of the context, and it can be read directly out of the speeches that, for example, Garvey and others deliver at the convention in Harlem in August 20. There's also direct inspiration being drawn from independence movements such as in Ireland, in Egypt, India, China, and across Eastern Europe. So there was really this internationalist outlook and learning from what was going on elsewhere. And of course, all the time there is the context of colonialism, especially in Africa. There's a constant reference there as well. I think when one looks at the content and the design of the document, one should also add one further context, and that is the kind of post-First World War constitutionalism. And one could, for example, as a particular theme here, mention some of the social rights constitutionalism of these years, 1918, 1919, and into the 20s. For example, the Weimar Constitution in Germany, the Mexican Constitution, and its experimenting with social rights, and also some of the Irish constitutional debates, which are after the 1920 Declaration, but can be seen in context. And I think comparison to the articles and what comes in this context, the 1920 Declaration, the UNI Declaration, holds up as also for its kind of quality in its drafting and its completeness and the type of issues that are addressed very directly. And I think the core reason for this quality and directing these issues is it's a very experience-based Declaration of Rights. It's not just a normative frame of thinking through legal principles. It's also the participants who spoke about their experiences from the different parts of the world that they came from. And those experiences are reflected in the articulation of the types of discrimination and the type of rights issues that are reflected in the declaration. And that makes it a really powerful document, also because it's so comprehensive what is captured. So as Garvey said at a speech at the annual convention, and I'm quoting him here, "We want this convention to clearly understand the universal Negro situation. We can only understand it when the representative from Georgia tells of the real conditions in Georgia, when the representative from Mississippi tells of the real conditions in Mississippi, when the representative from Basutoland or any other part of Africa tells of the real conditions in Africa, and so with the various islands of the West Indies and South and Central America." End quote. So this is where this experienced part comes in. They spent the first 1 to 2 weeks before they start drafting, really sharing experiences from, I mean, cities around the US, from different islands in the Caribbean, and also from Africa and places, especially in Central America as well. And this was a big event. I mean, on the second day, they could fill Madison Square Garden in Manhattan, and that would be numbering between 20 and 25,000 people that attended this special service or this special event during one of the days. And the opening event had about 12,000 people in Liberty Hall. So it was a big political and cultural event in Harlem during the month in August, and also generate a lot of media interest, and also from FBI and J. Edgar Hoover, who was already at this point breathing down the neck of Marcus Garvey and making life very difficult. So what is striking is that it contains a whole range of human rights across civil, political, economic, social, and cultural rights, as well as issues of equal treatment, non-discrimination, and also reflects on the nature of citizenship and citizenship rights. And I really recommend everyone to go to the link and read it in full, because I can pick out certain paragraphs, but I think this is also a document that deserves to be seen in full. The way the preamble with 12 articles, and then the kind of the main part with 54 articles, really is a comprehensive statement on these issues, and the way it's composed, even though there are some articles that are a little bit surprising. How does this fit into a Declaration of Rights? It's really quite a remarkable achievement that they did in less than 2 weeks, considering that also the UDHR, which of course had many states, it took 2 years to kind of draft that type of document. I think it's pretty impressive the way they reflected issues around torture, equality before the law, political representation, the right to work, the right to health, the right to education, and many other issues. And I think I mentioned that I did a lot of the early research of trying to stake out what was the Garvey Scholarship in late 2019 when I was in Oxford. But I did also a lot of the research and writing on this after I came home, and I think the context of writing up this piece really changed in the spring of 2020 and into the summer with the killing of George Floyd and the kind of Black Lives Matter protest around the world. The urgency of telling the story, of seeing how with such clarity a century before these issues were laid out in a large international rights declaration, was also kind of key in pushing that this story should be written. So I want to move to the point about the legacies and the further exploration or kind of research issue that comes up. So I think this document helps us renew our understanding of the evolution of human rights and the Human Rights Project itself across the 20th century. So what is so striking is that the vision of the 1920 Declaration shows that well before the 48 Universal Declaration of Human Rights, the linking of the broad categories of rights, and that is economic, social, cultural, civil, political rights, was vital for political projects concerned with liberty, justice, equality, dignity, and non-discrimination. We need to reshape the 20th century chronologies. I think too often we've treated the UDHR, which is also a remarkable document, and of course has had profound importance, but we too often narrate the story as the UDHR in 48 as the origin story of international human rights in the 20th century. And I think the 1920 Declaration is one of the sources that points us that in some ways the UDHR is also a continuity and a culmination of struggles that goes well before. And it highlights also the centrality of economic social rights, which are rights areas that have struggled for kind of support and legitimacy in that post-48 era. So I think the clarity on the declaration on these issues is quite profound. I think there's also more work to be done on or further historical exploration of the effect or impacts of the movement itself, the UNIA, and the 1920 Declaration. So one of the things I learned when I was doing this was from a Portuguese colleague, a historian of colonialism, who's written quite a bit on Angola and Mozambique. And he had looked at sources from the League of Nations in the 1920s. And when he heard I was working on this kind of declaration from Marcus Garvey and the UWI movement, he said, well, actually, a lot of the people who petitioned the League of Nations, the mandate system in the 1920s, were Garveyites. And this I had never heard of before, that one can potentially trace the significance of how petitioning became a legal technique in the international system in the 20th century, in international law, and especially international human rights law, that there is kind of a shaping influence of some of the early petitioners in the 1920s who happened to be kind of having been mobilized into the movement and would be labeled as Garveyites. And this is one of the things that I would really want to follow up on, but I recommend anybody with a chance. I haven't been able to go to Geneva all of 2020 because of COVID restrictions. But I think this is one of the ways we can prove that this forgotten and neglected document might have had a more profound significance in ways of just beyond just articulating kind of this rights framework, but actually in shaping how international organization developed in the 20th century. And there's some really interesting new scholarship out on the significance of the League of Nations, because it's often been seen as an organization that failed and couldn't stop the Second World War. But a lot of the research now on the 1920s showed that the League of Nations really shaped kind of internationalism in so many different ways. And it could also have done this in kind of the use of petitioning in raising grievances into the international system, also in the post-45 period when it's the UN that takes over. So this is one aspect which I think would be interesting to follow up on. There was also another dimension, and when I was working on this in Oxford, I had the chance to speak with a leading South African human rights activist, and also another person who had been on for 15 years in the Constitutional Court in South Africa. And I simply asked them to read this document, just saying, this is a significant document, right? Also from your perspective of kind of legal experts and human rights activists from South Africa. And they said, yes, this story needs to be written also from a South African perspective, because they were sure that they would be able to find influences from the 1920 Declaration on South Africa in the interwar period and beyond, because there were quite a lot of UNI chapters across South Africa, special concentration in Cape Town being one of the places. And I was able to trace members of Garveyites, so members of a UNI chapter in Cape Town at the 1923 meeting where the ANC prepares their first Bill of Rights documents. And that is seen as part of the ANC engagement with human rights across the 20th century, which is added with the African Claims document from 1942, the Freedom Charter from 55, and traces the story all the way to the post-apartheid South African Constitution in 1996. So even at that kind of interpersonal and movement level, there's these kind of paths that can be explored, and to try and give not just kind of knowledge about this declaration, so people can see kind of the rich contribution of it, but show that it actually had an impact that has been overlooked and deserves to be reassessed. So it is placed in the right context in the history of human rights on the kind of in a larger chronology. And I think also, and this is my final point, that the 1920 Declaration also opens up a whole range of broader questions relevant for both the global and the Caribbean context, such as what was the human rights project that we witness here, and what is the human rights project today? Because it speaks in so many ways, I think, to contemporary issues that we are grappling with as people interested in human rights or working in human rights, whether it's legal experts or project programs, or whether it's advocates and activists. I think it speaks to our kind of contemporary moment as well. And I think it fits in this longer history also, that you simply cannot write a credible history of international human rights in the 20th century without centering the Caribbean and Jamaica. And this goes, as I start out, from this document in the 20s to the work done in the 50s under the Manley government, very uniquely actually declaring a government human rights policy in 1961, which was supposed to be integrated into national development planning, and as a promise to the population of, kind of just before independence. And then also Jamaica becoming the global leader in human rights and being the first country in 1964 that integrates human rights into a foreign policy. So there is a trajectory there as well, which has been about making this history more representative and more accurate of how this field has actually unfolded, also globally, and the influences are transnational and global. And I think one of the early sources is this 1920 Declaration. So thank you for your attention, and I will pass on to Tracy, I guess.
Thank you so much, Stephen. Powerful first presentation on some big sets and some big interventions from you around the comprehensiveness of this document, the way in which it was guided by experience, and for many of us who have learned about the place of 1948 and the UDHR, the importance of moving backwards, and that this should never again be left out of key discussions about the history of human rights in the 20th century. Thank you so much, Stephen. I'm going to turn over to Ahmed Reid with his very special experience coming from the working group of experts on people of African descent, but also a historian. So we get to hear the perspective of another historian, and you may have seen Ahmed on some other spaces, including in the university space, talking about reparations, and he will add that to the discussion today. Over to you, Ahmed.
Yes, sorry, thank you, Tracy. Students at the Norman Manley Law School, specially invited guests, human rights defenders, ladies and gentlemen, welcome. Thanks again, Tracy, for the invitation. For me, this is a singular privilege and honor to address everyone here on this timely topic. 2020 was a tumultuous year. The killing of George Floyd has led many to call for an end to systemic racism, and state-sanctioned violence against people of African descent. New global risks such as climate change, environmental degradation, and pollution have posed an existential threat to the lives and dignity of people of African descent. We have also witnessed the onset of the COVID-19 pandemic, which resulted in the deaths of tens of thousands, mostly Black and brown people. The evidence before us is incontrovertible. Structural racial discrimination has further exacerbated the inequality in access to healthcare and treatment, leading to racial disparities in health outcomes and increased mortality and morbidity for people of African descent. The recent calls for justice, racial equality, and an end to systemic racism are not new. What the UNI's Declaration of Rights show, more than anything else, is that the arc of injustice towards people of African descent is long and extremely painful. The Declaration stressed the relationship between the crimes of slavery and colonialism and the ongoing harm and injury to the descendants of enslaved people. It is worth repeating what those crimes were. Over the course of 400 years, laws classified Africans and their descendants as non-human chattel, property, and real estate. They lost a basic right to their legal identity and as such remain invisible in laws, legislation, and policies. They were denied recognition, any form of justice, and subjected to the ideology of racism that demonized and denigrated all things Black and all things African. The cumulative result is racial inequality, structural invisibility, exclusion, and poverty. Blacks, the Declaration asserted, are, and I quote, denied rights due to human beings for no other reason than their race and color, end quote. It continued, any law, especially directed against the African and singling him out because of his race or color, is unfair and immoral. We protest, it continued, against the system of education in any country where Blacks are denied the same privileges and advantages as other races, end quote. I could go on, but as a member of the United Nations Working Group of experts on people of African descent that study and report to the Human Rights Council and the General Assembly on the human rights situation of people of African descent, the issues raised in the Declaration brims with familiarity. It is not far-fetched when I say that today, millions across the diaspora are asking the question posed by Ta-Nehisi Coates in Between the World and Me, how is it possible to live in a Black body? The absence of the Declaration of Rights in general histories of human rights is revealing. In 2018, we celebrated the 70th anniversary of the Universal Declaration of Human Rights, UDHR. But the 100th anniversary of this transformational document has largely gone unnoticed. But more importantly, how many here today can honestly say that they have read the Declaration of Rights? So what does this historical silence tell us? The Declaration was bold in its articulation of fundamental rights that were previously denied and which are still denied people of African descent. It stated that people of African descent are entitled to the equal rights of life, liberty, and the pursuit of happiness, and the right to even-handed justice. Put differently, it expressed that people of African descent have the right to the full enjoyment as a collective or as individuals of all human rights and fundamental freedoms. The call for even-handed justice was a call to end impunity. And Stephen talked about lynching and all those things before. More importantly, it centers on the right of people of African descent to security of person and protection by the state against violence or bodily harm. Violence or bodily harm includes ethnic or racial profiling, disappearances, extrajudicial executions, and torture. The goal then, as it is today, is to end the systematic and institutionalized targeting and killing of people of African descent. Article 7 of the Declaration addresses the issue of land rights, and that's something important to people of African descent, ancestral lands and all that kind of thing. The common theme of the Declaration is the right to reparation. The preamble framed it best. This was, and I quote, against the wrongs and injustices they are suffering, wrongs and injustices that were unrepaired in 1920, wrongs and injustices that we are experiencing 100 years later, and wrongs and injustices that literally and figuratively have disfigured Caribbean people. The call for redress, reparation, was a reminder, especially to those who perpetrated these indignities on our ancestors and beneficiaries, many of whom are alive today, that we must address them through reparatory justice. Many of you have read the results of the research from the University of London, where they've showed that the 20 million pounds that were paid to enslavers amounted to $17 billion today. And most of that money stayed in England and was reinvested in palatial homes and in institutions. We also know that British banks such as Lloyds, Barclays, Royal Bank of Scotland, the Bank of England, and the now defunct Barings all had links to the exploitation of Black bodies in Jamaica and the Caribbean. The act that should have emancipated enslaved people further solidified the racist interpretation of Africans and their descendants as property. No accompanying legislation was passed in 1833 to compensate the 850,000 enslaved people who suffered the trauma and humiliation of their enslavement. Many had high hopes and expectations of freedom. They had imagined a Caribbean society built on justice and equity, and one that would grant their children and grandchildren opportunities they were denied. What investments did enslaved people from Jamaica and other Caribbean territories make to realize their hopes and expectations, and more importantly, to secure a future for their offspring? We all know the answers to these rhetorical questions, and this is why the Declaration of Rights, as well as the reparatory justice movement, is framed within the discourse of development. While Europe developed through colonial exploitation, the plantation system that they created defined the social and economic outcomes of Caribbean people. In plantation societies, race and class determines one growth prospect. In the British West Indian Islands, the Declaration of Rights stated, and I quote, "Blacks are cunningly discriminated against and denied their fuller rights of government to which white citizens are appointed, nominated, and elected." Case in point, from the post-emancipation period onward, the newly freed people were thwarted by a colonial system that supported and facilitated land consolidation by the socially and politically connected white elites. Not given access to land, social and economic growth was difficult to attain by the citizenry. The edifice that colonialism created did not facilitate the development of the region's human and social capital. After all, that was not the intention. The Declaration of Rights calls for universal education and for the protection of that right, and you'll see that in Article 30 of the Declaration. This was an acknowledgement of the poor educational outcomes for people of African descent during the colonial period. In the Caribbean, poor imperial governance and the lack of imperial investment in the region's human capital is reflected in the educational attainment of Caribbean people at independence. The colonial mess that Caribbean governments inherited was evident in the illiteracy rate throughout the region. It was 60%, and in some countries as high as 75%. Poor imperial governance and the lack of imperial investment is reflected in the educational outcome at independence. The lack of access to education and widespread illiteracy subverted the development efforts of Jamaica, which continues to be a drag on social and economic development. So the low economic growth, therefore, and the resulting poverty trap and the multidimensional poverty that we see in the Caribbean are structural with deep historical roots. There is no other way to say this. Exploitation of the region's resources have damaged the Caribbean's development prospects. This must be acknowledged, and the continuing harm of colonialism, which was clearly stated in the Declaration of Rights, must be fully addressed if Caribbean people are to enjoy their rights to development. It is for this reason that CARICOM's 10-point plan for reparatory justice, which is aimed at repairing the harmful damages caused by European colonialism, and we can talk about that later on. As a conceptual framework, it will harness and strengthen the region's human and social capital and promote economic growth. And just in closing, I'll just say that 2015 to 24 is designated by the UN as the International Decade for People of African Descent. And there are three important pillars of the decade: recognition, justice, and development, all important themes which you see throughout the Declaration of Rights. But in closing, what I want to impart to you is that one fundamental aspect of the decade is a permanent forum for people of African descent. And that permanent forum is where people of African descent and human rights defenders can go. And the aim that one of the things that we are pushing for is the articulation of rights, fundamental rights for people of African descent that are not enshrined in any of these human rights instruments. And there, some of the rights that are articulated in the Declaration of Rights, reparations, the right to land, are some of the rights that we think it's important. So for those human rights defenders here, civil society, as we move forward, we ask you to encourage your government, your member state, to support the creation of this permanent forum so we can carry through the vision of Marcus Garvey and the people who were there at the convention in 2020, the aims that they were pushing for in the creation of these fundamental rights. And I will close with what they said. They said, these rights, we believe to be justly ours. I thank you very much.
Thank you so much, Ahmed. You know, the connection to reparatory justice and this declaration is an important one. The way in which you both outlined how the particular provisions in the declaration set the agenda for reparations. The close connection between your arguments and your ideas and those of Stephen relating to economic, social, and cultural rights being fundamental to addressing equality issues. Very important messages. Thank you so much, Ahmed. Can I turn over to Kacy Mordecai, who has been working on issues relating to citizenship and nationality for persons of Haitian descent and migration issues relating to Haitians in, amongst other places, the Bahamas and the Dominican Republic, and positions these questions in the context of the Declaration and continuing systemic racism. Kacy, over to you.
Thank you, Tracy, and thank you to the Faculty of Law at Mona for inviting me to be part of this masterclass. I'm absolutely thrilled to be on this panel with my colleagues and to be bringing much more attention to the Declaration, which I'll admit I didn't know very much about before this talk. And it's great to be among so many friends and colleagues in the field and students who are excited about human rights. So as discussed by Drs. Jensen and Reid, the Declaration is remarkable, right? And it's ahead of its time. It includes provisions on liberty, justice, equality, and dignity, as well as specific calls to protect civil and political, economic, social, and cultural rights for people of African descent. It's astounding for its time. I couldn't help but think about the articles of the Declaration when I considered the work that I do alongside organizations working on the ground in the Caribbean to combat anti-Haitian discrimination. So I work with civil society organizations in the Dominican Republic and in the Bahamas, and I'm going to shout some of them out here: Dominicanos por Derecho, Mostra, MUDA, Rights Bahamas, and many others. And they're fighting for the right to nationality for people of Haitian descent so that they may access many of the fundamental rights the Declaration affirms. In both the Bahamas and the Dominican Republic, the law restricts citizenship to children born in the country to people of foreign descent. So although these laws are neutral on their face, they primarily affect Dominicans and Bahamians of Haitian descent because Haitians make up a majority of the foreign population in both countries. So certain articles of the Declaration stood out as underscoring the importance of the right to nationality even from 1920, and the right to nationality is the focus of my work. So Article 7, we believe that any law or practice that tends to deprive any African of his land or the privileges of free citizenship within his country is unjust and immoral, and no native shall respect any such law or practice. And then Article 41, we believe that any limited liberty which deprives one of the complete rights and prerogatives of full citizenship is a modified form of slavery. So as Steve and Ahmed discussed, the Declaration was written from a civil society advocacy and activist perspective in the colonialist Pan-Africanist context of 1921. But these concepts are still very relevant today, using the Dominican Republic and the Bahamas as key examples of the situation of Haitians in the Caribbean. So turning to the Dominican Republic first, The 1865 Dominican Constitution includes the right to use solely citizenship or birthright citizenship. So that's what most of us are familiar with, that you're born in a country and you automatically get the nationality, the citizenship of that country. So in 1929, 9 years after the Declaration, the Dominican Constitution is amended to exclude children born in the Dominican Republic to foreigners in transit. And I'm using that in quotes. And foreigners in transit means people temporarily in the country for less than 10 days. And so that provision is intended to target children of Haitian migrant workers who cross the border to work in the Dominican Republic, particularly in sugar production. So for the next few decades, the Dominican Republic in policy and practice consistently withholds Dominican identity documents from children who are born to foreigners in transit. And they continuously expand this definition of foreigners in transit. So in 2010, the Constitution is again amended to deny birthright citizenship to children born in the Dominican Republic to non-residents. And what do we mean by non-residents? The broad category. It includes migrants without documents and persons who cannot prove legal residency. So in 2013, the Constitutional Court of the Dominican Republic not only upholds this restriction of citizenship that's in the 2010 amendment, it applies it retroactively to every child born in the Dominican Republic to foreign parents since 1929. So I want to put that in context for people in a way that I think will resonate more. That's if the US decided today to take away citizenship born to anybody in the US born to foreign parents since 1937. And immediately overnight, they changed that law. So we're talking about hundreds of thousands of people, multiple generations of people who lose their Dominican citizenship overnight. It affects their ability to get identity cards, ability to vote, find formal employment, apply for health insurance, receive state services. We talked a little bit earlier about COVID and the situation. Can you imagine if you don't have identity documents that allow you to access state aid, access the vaccine, access health services? It's exacerbating the situation of their vulnerability. So briefly considering the Bahamas, because I'm aware of time, but I also want to highlight the English-speaking Caribbean. So it's a similar situation. The Bahamian Constitution does not automatically grant Bahamian citizenship at birth to children born to foreign parents. Children born in the Bahamas to foreign parents have the right to apply for citizenship. So not the right to citizenship, but the right to apply for citizenship when they turn 18. And that process can take years. And what's interesting to note for both countries is that the Haitian Constitution does not immediately grant Haitian citizenship to children born to Haitian citizens outside of Haiti. So what that means is that if you're a child born to Haitian parents outside of Haiti and you don't inherit that citizenship automatically of the other country, you're effectively stateless until you get that other citizenship. And similar to what's happening in the Dominican Republic, in the Bahamas, Bahamians of Haitian descent also face issues with their identity documents for employment, bank accounts, tertiary education, and the vulnerability to expulsion and deportation. So going back to the Declaration, it's clear that the situation that I described does not comply with all of the provisions that Stephen and Ahmed laid out so nicely. So the discrimination of people of Haitian descent, though, in the Caribbean is not only due to race, right? Though race is a critical factor. I'm sure that a lot of you are asking yourself the question, it's a common question. How can it be racial discrimination when both parties are of the same race, right? So the Declaration, the way that it is written, considers a clear distinction between Black men and white men. It says, we the Negro people of the world, their reference is to an alien race. And I think it's a very interesting parallel to Haitians in the Caribbean. I also sort of wanted to talk about gender in this, but it being marked, but I don't think we'll have time for that. UN experts on minority and race issues described in a 2008 report in the Dominican Republic that the issue of racism is, I'm quoting here, almost invisible in certain parts of society, and in particular amongst elites who vehemently deny the possibility of the existence of such a phenomenon. The dominant perception amongst most Dominicans is that their mulatto skin tones distinguish them from darker skinned Dominicans and Haitians. The Inter-American Court has also noted the racial component anti-Haitian discrimination in the DR. They cited reports of racism against Haitians, not only on the strict basis of phenotypic traits that reveal African descent, but also on the basis of perceptions relating to the general aspects of those with dark skins. And that's from a 2014 decision. In a 2016 report that was done by a local organization in the Dominican Republic and my organization, RFK Human Rights, one of the victims explained to us, everybody who has a light skin color, it doesn't matter. When they go to the official registry, they don't pay them any mind. If someone has white skin, they could be Haitian, but nobody pays them any mind. But if that person walks in and they have a dark colored skin, everybody thinks that they're Haitian. So I'm not an academic or historical expert on Haitian-Dominican relationships, but the UN experts and others have recognized that this invisibility of racism can be the consequence of several factors, from slavery and colonization until the present day, that's across the region, but also the occupation of the Dominican Republic by Haiti and the achievement of independence of the Dominican Republic from Haiti, and the lasting impact in Dominican society of those political relationships. This legacy remains today, and again, I'm quoting, it helps to perpetuate negative and racist perceptions of Blacks, including Black Dominicans, those of Haitian descent, and Haitians. The factors of race and skin color profoundly pervade Dominican society, and racial prejudice is an important dimension of anti-Haitianism. So how do these ongoing anti-Haitian policies and practices, how do we consider them in the current framework about racism and equality in the Caribbean? So our understanding of racial dynamics and the concept of discrimination has to consider factors of color, class, descent, and natural origin. Consider the definition of racial discrimination in the Convention on the Elimination of All Forms of Discrimination. The term racial discrimination shall mean any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms. There's a clear shift to consider issues of racial discrimination amongst groups of the same race. And so this holistic perspective of race, I think it's summed up well in the article by the UN Special Rapporteur on Contemporary Forms of Racism, in the article that was sent out to accompany today's class. It talks about substantive racial equality and figuring out who holds the power. She argues that we must prioritize a structural and intersectional approach to racial discrimination and inequality, and carefully consider the social, political, and economic meaning of race, especially when policies are neutral on their face. And that's the situation in both the Dominican Republic and the Bahamas. Those policies are intended to, and they achieve discrimination against a particular group on racial grounds. So to harness the full power and value of the Declaration, because I'm so excited to talk about these articles of the Declaration with the people that are still on the ground, trying to strive for a lot of these same ends, we have to keep the nuances about the concepts of race in mind and what the full dimension of race means. And I think that is really how we harness the true power of the instrument. I'll turn it back over to Tracy.
Thank you so much, Kacy. Many people joined in to hear you today. They were very interested in the discussion which you just presented, the invisibility of racism in the Caribbean, the incorrect presumption that racism is not an issue in African descendant dominated countries like ours. Extremely valuable, Kacy. Thank you so much. I know folks will have many follow-up questions. Margaret May Macaulay, who is joining, has thought a lot about these, and she may join us in the comment section as well, But let me turn over to the course director, who has been thinking about these questions in a much broader context, Ramona Biholar, who is going to talk about a case which many of the Jamaicans who are listening know about. If you haven't heard about it, look in the YouTube chat and we'll provide some more information on the Virgo case. Over to you, Ramona.
Thank you. Thank you very much, Tracy. And to briefly say first that I'm thrilled to have this special company discussing and understanding more the UNIA Declaration, Marcus Garvey's legacy. While a statement of intent being a declaration, the UNIA Declaration stands as proof of a human rights vision, and my fellow panelists showed it clearly. A vision that brings to attention in 1920 issues that have dominated global human rights debates from 1948 onwards, with the birth of the UDHR, Universal Declaration of Human Rights, and the American Declaration on the Rights and Duties of Man. It can be said that the Declaration is a precursor to current international human rights documents. It covers the entire spectrum of civil, political, economic, social, and cultural rights premised on the fundamental principles of equality and non-discrimination. We see the ideals and intentions expressed in this declaration reflected in the Universal Declaration of Human Rights and the American Declaration, and also formulated in legally binding language in a number of international human rights treaties. To further show this connection, I'll focus on education, which both Marcus Garvey and human rights treaty bodies see as a transformative and empowering tool. UNIA Declaration addresses education in Articles 22, 30, and 31. In Article 22, and you have there on the screen a couple of, I could not cover all the articles that are relevant, but a couple of them. But in Article 22, the UNIA Declaration brings attention to racial discrimination in the area of education and calls for racial tolerance. In Article 31, the Declaration speaks to the rejection of education based on race ideologies of superiority and inferiority. And Article 30, on which I focus today, demands the right of unlimited and unprejudiced education. Similarly, the current international human rights framework addresses the right to education in, and to name a few, Article 26 UDHR, Article 12 American Declaration, Article 5V, Convention on the Elimination of All Forms of Racial Discrimination, Article 13, Covenant on Economic, Social, and Cultural Rights, Article 29, Convention on the Rights of the Child, the UNESCO Convention Against Discrimination in Education. According to this international human rights framework, the normative content of the right to education refers to all types and levels of education and is premised on four interrelated essential features: availability, accessibility, acceptability, and adaptability, with dignity of the human personality as one of the mandatory objectives to which all education is to be directed. I focus on accessibility for this discussion, which mirrors the demand for unprejudiced education in the UNIA Declaration. Accessibility of the right to education, according to the Committee on Economic, Social, and Cultural Rights, means that educational institutions and programs have to be accessible to everyone without discrimination within the jurisdiction of a state party. Non-discrimination in this context means education must be accessible to all in law and fact, without differential treatment, exclusion, restriction of a person or group of persons intentionally or in effect based on his, her, or their particular status or situation, such as race, gender, class, so on and so forth. In light of this international human rights framework on education, given that Jamaica is a party to all the legally binding treaties I just mentioned, and thus having a legal obligation to bring in line its laws and practice with these international standards, and in light of the idea of unprejudiced education in the UNIA Declaration, I'd like to examine the school policy of no braids, no beads, no locking of hair, the point of contention in the 2020 Jamaican case, well known as the Virgo case. And briefly, in this case, the parents of ZV, who wears her hair locked, were told that their child was not allowed to attend the school unless her hair was unlocked. The reason given was, quote, that the classroom gets hot and parents do not wash their hair, causing John and lice, end of quote. As CEDAW committee highlights, in many societies, prejudices based on gender, class, and or racial stereotypes are reinforced through schooling, helping to maintain the racial, class, gender order of society. So my focus is whether, under international human rights law and in light of the UNIA calls for unprejudiced education, the school policy discriminated against ZV. I'm not examining the court decision itself. So the policy does reflect stereotypical beliefs about locked hair as being associated with lice in absence of an actual school hygiene threat and irrespective of ZV's actual circumstance. And to clarify, stereotypes are generalized views that ascribe particular attributes or characteristics to members of a certain social group and create expectations of how they should be or act irrespective of individual features, qualities, circumstances. And in the words of Professor Rebecca Cook, stereotypes limit the full and the diverse expression of human character. And this means that stereotypes infringe unduly on the capacity of individuals to construct and make decisions about their own life plans. To the extent that stereotypes ignore particular individual circumstances and puts the individual in a disadvantageous position, it has the potential to bring about discrimination. The decision to ban certain hairstyles, typically culturally associated with black hair and texture, singles out an identifiable group and falsely ascribes the characteristic of an unhygienic hair to that specific group, creating negative portrayals of and expectations from an individual who wears that hairstyle, and in this case, that be irrespective of her personal circumstances. Such false stereotypes, also known for assigning difference, treat social groups as something they are not, and in doing so, reflect prejudice and devalue the respective group and the dignity of its individual members. There is no guarantee the other hairstyles that do not include locked hair are not at risk of lies. But to establish discrimination based on stereotypes, we need to ask here whether the policy of banning locked hair is proportionate with the aim of ensuring hygiene. Alternative approaches, less intrusive, could be established to ensuring hygiene in schools. So the differential treatment imposed by the policy, I say, is disproportionate. More so, there is no actual threat, health threat that would justify limitation of rights, and banning hairstyle associated with natural black hair and texture, and by extension excluding students who display that hairstyle results in the impairment of students' exercise of their right to access education and violates students' dignity and a sense of black cultural identity. Clearly, the negative effects of stereotyping outweigh the benefits of the differential treatment and go against requirements of non-discriminatory access to education. Thus, it is direct discrimination, as the policy on the basis of stereotyping disproportionately targets an identifiable group and affects the right to access education of ZVs as part of that group. Other students wearing their hair in different styles were not suspected of having lice and thus not excluded, right? But we could also be alerted, and this, I would say, even more going further into the issue, to indirect discrimination. Because in a multicultural society, children from a particular demographic, children of African descent, are disproportionately affected. We are concerned here with the effect of the policy which reinforces pre-existing hierarchies and ideologies in the society that black texture hair is dirty and inferior. This type of discrimination is rooted in and perpetuates racial prejudices and ideologies of inferiority, signaling structural or systemic discrimination by which prejudicial attitudes and views permeate structures and institutions. Like other rights, the right to education imposes three types of legal obligations on states: obligation to respect, to protect, and to fulfill each of the essential features: availability, accessibility, acceptability, and adaptability of the right to education. The policy in discussion raises questions about compliance with state obligations to protect ZV's right to education, which requires ensuring that third parties do not interfere with the enjoyment of her right. Elimination of stereotypes and prejudices is central to the respect and protection of this right to education, and domestic courts have a special role to play in ensuring its protection. Courts must be expansive in their interpretation, and I would refer to the CEDAW case, Cristina Munoz Vargas versus Spain, where it says that courts must go beyond the obvious consequences of discriminatory acts and recognize the danger of ideology and norms that underpin such discriminatory acts. The policy goes against the Convention on the Elimination of Racial Discrimination, Articles 1, 4, 5, 7, and Covenant on Economic, Social, and Cultural Rights, Article 13, and the idea of unprejudiced education in the UNIA Declaration. And I'll conclude by saying that the court had the opportunity to interpret international human rights norms that Jamaica has committed to through ratification, and thus give meaning to its legally binding obligations under these treaties. Instead, the court has taken a limited approach, not adequately observing the human rights norms, but by extension, considering the significance of the UNIA Declaration as a ground for subsequent international human rights treaties, Indirectly, this is a missed opportunity to uphold the Declaration's ideal of unlimited and unprejudiced education. And this signifies that the goal for available and accessible education, to which Marcus Garvey aspired to and expressed in the Declaration, is yet to be fully attained 100 years after, when a policy of no locking of hair is into place and can restrict a child's access to education of her choice. And I would say, and I finish here, that the intentions of the Declaration should be brought into light, like Stephen advised us earlier, in international human rights discourses, and more so because of its continued significance, especially in the setting of the Caribbean societies. Tracy, over to you.
Thank you so much, Ramona. Unprejudiced education. Wished we cited that in the Virgo case, such a valuable way of connecting the question of race and education, and your important analysis of how stereotypes are part of the framework of racial discrimination, and linked to Kacy's discussion about how racism remains relevant to all parts of the world in which the majority populations are of African descent. Thank you so much to all of you. Ramona is going to jump over to the moderating role, and I wanted to open up the floor. We have about 20 minutes until 4 o'clock Jamaica time, and I'm going to ask now for leave for about 5 to 10 extra minutes because I imagine our discussions may continue for about half an hour. I'm going to give the floor first to some of our guests in the room. And I'm going to start with the head of the UNIA in Jamaica, Stephen Goling. And I am just going to ask Margaret May McCall if she has a few observations after Stephen before we move on to another set of comments. And at some stage, we'll begin to ask the guest teachers their responses. But let's start with Stephen and Commissioner Macaulay. Mr. Goling.
Thank you, Tracy, and let me comment and congratulate everybody for their presentations. Couple comments, as I heard Mr. Jensen talk about how surprised he was to encounter this document. But I want to say that that document was presented to the League of Nations, any resemblance between the UDHR and the Declaration of Negro Rights. Quite curious, knowing that that particular document is in the archives of the League of Nations, which, you know, I'm sure the United Nations inherited. But I also want to say that the engagement between the UNIA and the League of Nations did not start with this Declaration of Rights. They sent representatives there because we felt that if you were having a united sort of world representation, no one was at that
Steve, we're having trouble with your audio. Wondering if you come off video, we will hear you.
African descendants or for the more. Let me try that.
Thanks, Stephen. Go ahead.
Better now?
Much better, Stephen. Go ahead.
Yes, so I just wanted to point out that in 1919, the UNIA, supported by the League of Darker Peoples. The League of Darker Peoples was a group of Africans in the United States, which included Adam Clayton Powell Sr. And Madam C.J. Walker, one of the first African-American millionaires. And they sent a delegation to the Paris Peace Conference, which it was a delegation of 3, but only one was granted permission, whether through visa to land. And that delegate was a Haitian by the name of Eliezer Cadet, right? Very important person, and later went on to become a top Hungan or voodoo practitioner in Haiti, but that's a story for another day. But it was because of the reaction of the League of Nations in 1919 not to seat that delegate because they said he represented no nation. A number of things happened there in Paris, including the UNIA connecting with the Ethiopian delegation, with the Liberian delegation, which led to the Black Star Line and the Liberian program. But because of how that delegation was treated, that is why in 1920, the Declaration of Rights of Negro People of the World was produced at what was not the first UNIA convention, even though history regards it as such. What it was the first convention where we had a full representation of divisions from around the world. And that's why one of the declarations states the League of Nations, in our opinion, is null and void. It was a reaction to the treatment in 1919. And the second point I want you all to understand is that at that convention in 1920, it wasn't just a convention to sort of deliberate and come up with these declarations. It was also a convention to establish a provisional government of Africa, which Marcus Garvey was elected by a delegation of 25,000 representing 400 million around the world, right? He was elected as the provisional president of Africa. So when that document came out at the end of that convention, it really was a statement of this future government of Africa, this government in exile, so to speak, stating our position as a race and what we were demanding of the world at that time, you know, because in 1919, the delegation that went to the League of Nations didn't carry a Declaration of Rights. What they carried was a request for the German colonies that were confiscated by the League to be handed over to the UNIA, which was representing African descendants around the world, for a program of repatriation and reparation. So I want to big up my friend Ahmed for contextualizing that, but there's so much more to the story. I wish I had time to go through all of it, you know. So there's a progression from our first engagement with the League, their reaction to us now organizing a provisional government and making these declarations, and also the continued pursuit that Marcus Garvey kept up well into the 20s and into the 30s, himself going to Geneva. So I would encourage my namesake, Stephen, to challenge the UN archivists to see if they can find those documents which were presented on one occasion by our founding President General himself, right? Because I am sure those documents were seen and were known of 2 decades before the Universal Declaration of Human Rights. Some of it may have even been copied. I don't want to say plagiarized, but I'm sure it had a greater effect than our historians are writing about. Thank you.
Thank you so much, Stephen. Challenge to the archive. I'm going to give Stephen, Jensen, and Ahmed an opportunity to respond. Let me recognize Professor Rupert Lewis, Professor Emeritus in the room on the YouTube, who has been acknowledged elsewhere in this session. Thank you so much, Prof. Lewis, for being here. Can I give the floor first to Margaret May Macaulay before giving some of the guest teachers a chance to respond? Thank you so much, Stephen. Margaret?
Thank you. Oh dear, I think it's not muted.
We're hearing and we're seeing you, Margaret.
Okay, lovely. Thank you, Tracy. This has been a very interesting and very well planned discourse, and I'm really happy you invited me to take part. But as the rapporteur in the Inter-American Commission for Afro-Descendants' Rights and Against Racism, I have, since being in the Commission, I have been rather embarrassed by the paucity of work which has been done by the Commission over the years. But it is a twofold blame. One is that not enough people know about the Commission and its work in order to use the mechanisms in the Commission to advance the rights of Afro-descendants in the region. And as we all know, racism is rampant in our region, North and South, and Central American countries as well. And it is against all persons of color, but most particularly against persons of Afro descent and indigenous persons. And they are discriminated in every respect. So it was with, I just have to mention this, that I thank Stephen for his talk, is mentioning the fact of Jamaica's involvement and adherence to human rights, and very early on, and continue. But it is a disappointment that Jamaica has not ratified the Inter-American Convention against all forms of racism, racial discrimination, and related forms of intolerance, which came into force on 11th November 2017. And in fact, only 12 states in the region have signed this convention, and 5 have ratified, and only one from the Caribbean, and it is not Jamaica. And of course, married to that as well is the Inter-American Convention against all forms of racism, discrimination, and intolerance, which also came into force in 2020, February last year. And that has also been signed by the same 12 states and has only been ratified by 2 states. So it seems to me, as the rapporteur, that we have a very long way to go for states to take their obligation seriously when it comes to dealing with racism and racial discrimination, which are ongoing in their countries, both structurally and systematically. And so we have been trying to, since I assumed the position of rapporteur, to broaden our effects in the region in this regard. But I wanted to ask Stephen Jensen a question in relation to the Inter-American Declaration on the Rights and Duties of Man, which came, in fact, preceded the Universal Declaration by 7.5 months. Whether or not the Inter-American Declaration, does he think, and does he have any information, supplied basis for some of the articles in our declaration in the Americas, and which wouldn't surprise me at all. And I do wish we can have a further intervention of this kind again in the future, because it will assist us greatly in the Commission to learn more about the history of these issues and how they were dealt with within our region in the Caribbean. Can I say thank you again to all the speakers who are very superbly clear and interesting and informative. Thank you.
Thank you so much. Ramona, a lot of questions from students, if you have noticed. So we've had a number of students who wish to ask questions, but maybe Ramona, before we take some of those questions, which you could perhaps share, we could ask the guest teachers if they want to briefly comment on hearing from the rapporteur in the Inter-American system, Commissioner Macaulay, as well as Stephen Golding's analysis and explanation of more of the history of this declaration. Could we perhaps take in the same order with Stephen Jensen first, briefly?
Okay, I'll try to be brief. I couldn't hear all of Stephen's intervention, so I'll try and respond to what I can. I appreciate very much the additional perspective, because there were other things on the agenda and going on at the 1920 convention, but they do on several occasions say that the main ambition is to draft this declaration. That doesn't mean that the other things weren't central to the whole mobilization and the mobilization around this declaration. In terms of the international aspect, there is also an article in the declaration where they actually demand representation in international bodies. So that, of course, reflects that there was definitely issues going on about that relation to the League of Nations. In terms of the archives, the League of Nations archive is actually separate from the United Nations, even though they're both based in Geneva. And I'll definitely be willing to challenge the archivist there and look into what can find. I think it's really promising a lead if we can find out that those early petitioners to the mandate system were often Garveyites, because that shows really the outreach of this movement, and also how this movement reflected back to the kind of center of international organization politics in pushing their claims. And I would like to see how much that was done from the movement agenda and how much was specifically drawing on the declaration itself, because I want to see if we can enhance the importance of that declaration. I'm not a Garvey scholar, I'm not a UNI scholar, but I think I've addressed what is a gap in that scholarship by trying to elevate this declaration. That would be kind of my lead on this issue. I couldn't quite hear Margaret's question to me, but if it was whether there's parts of the 1920 declaration that influenced the later inter-American documents, I haven't linked that yet, and that's because I haven't been able to do the research beyond that. But I think it's an interesting question to pursue. What is also striking is how much actually human rights and constitutional rights thinking that took place in the interwar years. And really, it's a much larger discourse. I mean, there's a 500-page document compiled by the ILO in '44 about all of these kind of constitutional provisions that speak to social and economic rights in the post-45 era. So there's many strands going together there. So I can't say anything affirmative about the direct links, but it'd certainly be interesting to see how it shaped a regional discussion throughout the 20s and the 30s into the 40s. Thank you.
Thank you. Ahmed, any thoughts, or Kacy?
Well, thank you. Just to thank Stephen Goling for his intervention. As like Stephen Jensen, I'm not a Garvey scholar, so the wider context that Goling presented was much appreciated, and it goes back to, I've read this Declaration of Rights quite a few times, and while Stephen was talking, I went back to Article 49, I think, which not only does the rights talk about the universality of education, but a particular type of education as well, and an education that is Afrocentric in its context. And I think that is something that we need in the Caribbean, and why we have always said we should make history mandatory, and the teaching of history, because a lot of us need to know this, and we need to know the larger context in which not only the Declaration but Garvey and his work. So I was just interested to hear what Stephen was saying, and so just again, thanks Stephen for that.
Yeah, I would just take the same path and just say thank you, Stephen, for that, because one of the things that reading the Declaration does for me is thinking through how we can view a lot of these problems from a historical perspective about race and racial discrimination. That's not something that the Caribbean talks about a lot. And particularly for the inter-American system, I think there are ways that we can use this 1920 declaration to reframe the conversation, not only as a historical one, but as a current one, because the connections are there. So thanks so much.
Thanks so much. Ramona, can I hand over to you? This is a classroom, and it turns out many of the students in the classroom are very interested in asking questions. over to you.
Sure, thank you, Tracy. And I think we have a couple of undergrad and graduate students wanting to ask some questions, and I will invite Ronaldo, who can take the floor to pose his questions to the panelists. Ronaldo, over to you.
So we may need to unmute Ronaldo on our side. And while we're waiting on Ronaldo in a second, go ahead, Ronaldo.
Yes.
So Ronaldo is in second year doing Commonwealth Caribbean Human Rights. Go ahead, Ronaldo.
Thank you, Ms. Robinson. Thank you, Dr. Biholar. So my question is spurred on by Dr. Jensen, but I believe any of the subsequent panelists could also offer insight if they feel to as well. So my question is, what do you think contributes to the continued relative obscurity of the Declaration? Is it an issue of relevance, or is it ignored by our human rights systems? And is there somehow a link to race?
Thank
you, Ronaldo. And I would say we can take 2 more questions while the panelists prepare their answers. So this would be for Deandra, another undergraduate student, who is asking, the Caribbean has a dismissive attitude towards our own human rights issues, especially those tinted by color. How do you think bringing this declaration to the forefront of our education would promote transparency and accountability of our own human rights issue? And this is directed to Ms. Mordecai, but also the other fellow panelists can answer. And I will just ask one other question, and that would be for a graduate student, Christopher Orumba, who is saying that, well, I will just quote his comment and question. For how long can we blacks, especially from Africa, continue to erode these human rights of our people, especially through orchestrated killings along the lines of ethnicity, religion, and culture? Even despite clear court's orders and awards of compensation against these blatant infringements, most African governments keep silence. And a suggestion that these breaches are masterminded by governments through their officials. And he's asking whether we are yet ready for a genuine pursuit of human rights. So let's hear some ideas about these in response to these questions.
Anybody wishes to jump in? And if I could take the risk of saying, I'm sure the audience wants to hear from Stephen Goling again at some point before we wrap up in a couple of minutes. But Kacy, Ahmed, or Stephen, any thoughts on some of the comments so far?
So I can jump in really quickly. I think some of those are related. So on the question, and I'm paraphrasing here, the dismissive perspective towards race and whether this declaration can contribute to transparency and accountability, I think yes, that's exactly what my hope for it would be. I do believe that a lot of Caribbean governments are dismissive about race. I think, just to take the example that I probably know best, the Dominican Republic in responses to the UN has said something, there's no problem with race, everybody's the same race here, essentially. And so I think, one, we have to talk about race in all of its aspects, but also think beyond, as I was talking about, just race as white versus black and minority versus majority, which I think is how a lot of folks in the Caribbean understand race, but like really taking that apart and sitting with it and using that as a human rights issue and not just thinking about human rights issues as, solely on torture without sort of the links to racial aspects and these kind of big picture items and not really unpacking all of the components of it without thinking about race. I don't know if anybody wants to jump in there.
Any other thoughts? Go ahead, Stephen.
Okay, so this is to Ronaldo's question about the obscurity of the declaration. I think it's multifaceted. I think there's a range of reasons. And I think one of the problems is for decades, literally, we were reproducing narratives about human rights history around the 1940s and 70s and always privileging kind of the Western narrative here. And that is linked to race. It's also linked to lack of scholarly imagination and laziness by scholars. So there's different aspects of this. I've used some of my research to criticize some of the US human rights historiography, for example, at something called the Society for Historians of American Foreign Relations. And I found actually them quite receptive to what I presented about. We need to bring in this global South perspective. We need to understand their role in shaping this system as activists, as diplomats, as lawmakers, and so on. So it's actually a variety of reasons, and we need probably to explore those to figure out why those gaps. But there is right now a real interest in the contributions from the global South into creating this kind of human rights. It's one of the frontiers of research, I would say, in human rights historiography. And then we also need to acknowledge the inequality in research funding to do these types of stories. It's much easier being an academic at a West European or US-based institution to do this. So we're struggling getting in the global South perspective. And it's a bit shameful for my part of the world when it's actually a country like Jamaica that laid the whole foundations for the legal, political, diplomatic breakthrough of human rights that has taken so long for us to discover it, because it's not Jamaican history, it's Danish history, it's British history, it's European history, it's American history, and so on. So there's something there as well we need to address of how we get these in more systematically, these perspectives in. And it's varied. Yes, it's linked to race. It's also linked to other reasons that we need to address. Thank you for your question.
And Ahmed? And I know Stephen Golding wants to jump in on this one, so Ramona, could we just take him after Ahmed? Thanks.
Yes, thank you, Tracy, and thanks for the questions. Let me touch a little on what Ronaldo asked earlier. One of the things when you look at the declaration is, and I've said it before, it's bold articulation of rights, and one of those rights, when you go through from number 1 to number 54, throughout that is the right to reparations, the right for repair and redress. And that's what sets the Declaration of Rights apart from any other human rights instrument that I've looked at in that context. Reparations for historical wrongs, for harms and crimes committed and for which people of African descent are still experiencing. So it called for a bold vision, and look at where the call for reparation is today. Look at how it's been treated. The call for an apology has not been given. The call to address some of the social and economic conditions and consequences have not been addressed. So when you look at it historically and look at the fact that Haiti had to pay reparations to France, and you look at the history of who have gotten reparations, and look at what was asked for in the 1920 Declaration of Rights, it's not far-fetched to see why it's been ignored, because it was calling for, and it was asking for a vision that they were not willing to accept, and one with which even today they're still not willing to push forward. So, for example, the right to land, it's not enshrined. It's not a fundamental right, or the right to ancestral land, even in that context, is not a fundamental right. So race is an issue, Ronaldo. Why it's been ignored and continues to be ignored. The issue for me, though, is why our people, and it goes back to the last question on whether or not, we should have a genuine pursuit of human rights. Yes, of course we should. The permanent forum is pushing, and the need for a permanent forum is the need to push for the promotion of these fundamental rights which we have explained in the 1920 Declaration of Rights which are still being ignored and being denied, not say ignored, but being denied, but right with which we should be as people of African descent enjoy: the right to land, the right to security of person, the right to reparations, These rights are critical. These rights are fundamental, and therefore, yes, I hear the issue that you've mentioned in terms of extrajudicial killings, and yes, governments have been involved, but that will also give protections, even from our own governments in this context. So it is worth pursuing. I think that's my takeaway, that these rights are worth pursuing.
Thank you so much. Ramona, should we just take briefly Stephen? The other Stephen.
I would say so. So
I just wanted to say in response to the questions of obscurity and lack of recognition. One of the issues is that the very Declaration of Rights of the Negro people of the world, the factors that drove the UNIA to even creating that document, were completely ignored by the League of Nations, and it exposes sort of an innate racism and a prevalence of the white supremacist mindset, which eventually enveloped the League and suffocated it. I mean, even after Ethiopia was admitted, the way the League dealt with the situation of the Italian-Ethiopian War and their failure to do so, which led to World War II and led to their own failure. So I think, because of that embarrassment, plays a lot in why, these documents may not be spoken about, even though they were known.
Thank you so much, Stephen.
But can I just ask a question, if to the other teachers and also to Stephen? Is yes, Stephen, internationally, but my question is, I've talked to friends since I've been invited, and they were like, "What declaration are you talking about?" Even folks who are in human rights. So my larger question is, why is it that even within our society there is this, as I said, historical silence around the document? Even within and amongst Jamaicans, there are folks who have never heard of the declaration. So what is the reason for that?
And what can we do about it?
Yes, and what can we do about it?
We're still talking about teaching Garveyism in schools, even though it's being done in some schools. We're still talking about, how to mandate it by the curriculum. So that doesn't surprise me. I mean, anybody who's read the philosophy and opinions of Marcus Garvey cannot miss the Declaration of Rights of the Negro people of the world in there. It's a fundamental part of that book. And so the fact that people are saying they don't know that even exposes more, this lack of teaching the philosophies of Marcus Garvey in our schools. So, I mean, I work in that field, so I feel like I preach it every day. So you have to forgive me on that part. But we've gone to the teachers' colleges, and it's been a snail's pace even getting them to make it compulsory. Progress is being made, but again, as I've always said, teachers don't teach what they themselves haven't been taught. So if we're going to address that problem, that's where it starts.
Thanks. And I think a pointed question to folks like me and Ramona and other human rights teachers is, where is this in the content of human rights education? And I think we take that pointed question and must respond. Ramona, a few more and we'll wrap up in 5 minutes.
Yes, thank you. Thank you, Tracy. And there are 3 more questions that I want to pose to the panelists, but I just wanted to also make a comment because on the marginalization of certain voices in international human rights discourses. So what I also noticed in my work and research that, and especially looking at the UNIA declaration, that a number of other voices are marginalized in international human rights discourse. So there is the right to development, which is a particular right controversial and much debated in the international arena, which is very clear on the African continent for the African Commission. It is justiciable in the African Charter. However, at the international level, states are still debating whether to recognize it as a justiciable right in the international human rights legally binding treaties. And this also makes us think about the asymmetric relation between countries, global north and global south, and what voices are recognized in this international human rights discourse. Because obviously through this right to development, countries from the global north will be held accountable, especially from their colonial past. So I just wanted to also add that into the discussion, but I will stop there and ask a couple of questions from students. And one is from Shanae Morgan, who is asking, what are the panelists' thoughts on the region moving away from the UDHR, United Nations framework and mechanisms, especially in light of criticism that the UN bodies have become tools of powerful nations to punish the less powerful? That's one question addressed to the panelists. I will ask the question from David Moyston, who would like to hear about the inclination of some CARICOM states to seem to prefer aliens from white countries over those of fellow Black CARICOM countries on a daily, everyday manner. So shall we go with these two questions to the panelists? Some thoughts, some comments?
Yes, and is it too much to impose, a quick turnaround, 30 seconds to wrap up with any final thoughts as well, and also to reflect on the questions? Thanks so much to each of you. Maybe starting with Stephen.
Okay, I don't have so much to the questions because they're a little bit out my area of specialty, but I think when we talk about the lack of the presence of this declaration teaching, we should also ask the question, why has it been so absent from Garvey scholarship itself? Because, I mean, I have not read everything or looked at everything, but it's striking that it's like one line in passing references. I mean, I found one book from the 70s that describes it over 4 or 5 pages, and I know that Garvey himself and the UNI is a many-faceted movement, and there's so much to study. But I think it's still striking that it's even been absent from the Garvey scholarship itself. And that's also something that needs to address, also if you want to have it as part of teaching. So that will be my final intervention. Thank you, everyone.
Okay, I'll be brief. On that question, I think it was the second question. I go back to my point. Read Article 49 of the Declaration of Rights and what it is emphasizing in terms of the type of education. History education is important. History education is critical. If you look at the numbers doing history at CXC, every year it seems to get less and less. What that tells you is that you have future leaders of industry who are not grounded in Caribbean history, grounded in the teachings of Garvey and so forth and so forth. One aspect of that is Haiti. And we know the problems Haitians have had and have been experiencing in the Caribbean. But a deep study of history will prove that the people of the Caribbean owes Haiti a lot in terms of what Haiti has done for the region as a beacon of revolution and resistance. And the fact that Haiti are having the audacity to declare its independence and was stifled diplomatically, economically by that, and had to pay French reparations, and the long-term legacies of that on the people of Haiti. So I will answer that question by encouraging and suggesting a need for history education, and the need for history education to be mandatory. And you go back and look at Article 49 of the Declaration, and it was on point in the need for this kind of stuff. So I'll answer the question that way. And again, thank you.
Kacey?
No, I've been thinking a lot about both questions. I think we could spend another 2 hours on each of them, honestly, kind of the idea of, so I think there is a clear racial distinction to sort of who countries want to let in and who they don't. And I think that's something that we have to unpack as a society. But that's not just about migration, or it's not just about who is migrating. I think that speaks to a larger societal systemic problem about racism, and something that needs historical education, but it needs addressing at all different levels and not just the migration level. So that's a short answer to a very, very large question that I'm sure we're all thinking about in different ways. And then the second one about which systems the Caribbean should look to. I think partly, and I don't mean this to be a cop-out, but I think that's sort of the wrong question. I think there are issues in the Caribbean that need to be dealt with, and we have many frameworks for doing it, but I think, again, those are intrinsic issues, and thinking about the ways that those problems that can be solved rather than putting up barriers. I don't know if that makes sense, but like thinking about positive solutions and not just sort of what the issues with the systems are.
Thank you, Kacy. And I will also jump in to actually totally agree with you in response to the question on the getting away from the UN mechanism. I think having different systems of protection, it is useful for the realization of human rights for rights holders in their different realities, but also we need to think about the UN as offering a system of accountability for the states to self-assess in their record of human rights, apart from the UN politics of power. And I would say that for that matter, UN and the other mechanisms, the regional mechanisms are important, and we can look at the half part of the glass, even if there are gaps there. So I would not take more of the time.
So we just have to say thank you to everybody. It's
right.
It almost sounds as if we need a part 2, Ramona.
I would say so. I would say so because there are more questions that unfortunately we could not take all, and perhaps we should meet again.
And it says something about the importance of master classes in areas like this. We've held many in corporate and commercial law. We really value the opportunity to do it in your course in international human rights law. Deep appreciation to Stephen Jensen, to Ahmed, Reid, to Kacy, to Ramona for making her class a public space. You know, for most of us as teachers, we are teaching in closed rooms, even virtually. So we have valued Ramona being in your classroom today. Thank you very much. Deep appreciation to Professor Lewis, to Stephen Goling, Margaret McCauley, Nancy Anderson, Carla Gulotti, who is here, many others who have been joining us all around the Caribbean and further afield. We are grateful you're with us today. Join us next time round. Thank you very much.
Thank you for having me, and thanks again.
Thank you.
Thank you very much, everyone.
Blessings.
Thank you, everyone.